Okay, good afternoon, members. Today we're going to get a briefing on age discrimination legislation in relation to the provision of goods, services and facilities, or GFS. We have a joint briefing from the Northern Ireland Commissioner for Children and Younger People, the Equality Commission and the Commission for Older People. And that will be followed by a briefing from the Children's Law Centre on the same issue. So we start with apologies, members. We have apologies in from Leslie Cree, who's got a commission meeting, Megan Fearon and Brenda Hale. We take it everybody else is due.
Chair, can I tender apology on behalf of Jimmy Spratt and George Robinson both?
Jimmy Spratt and George Robinson.
Megan and Alex will be in late.
Oh, Megan will be in? Right.
Yes.
Okay. Thank you for the clarification. Okay, members, to go through our paperwork, page 5, we have a request from Children in Northern Ireland who'd like to brief us on the consultation event that they held on delivering social change for children and young people. It undertook a consultation with 160 member organisations. The department, I think, is going to brief us on the results of their consultation process in early May. So this might be an interesting counterbalance, possibly even a reassuring affirmation of what the department tell us. So shall we schedule for around that time?
Agreed.
Thank you. Page 8 is the committee's current invitations. Please note we have an event this evening, members, an exhibition entitled In the Garden of Europe at 6:30 in the Great Hall. We've all been invited. I'm afraid I cannot make it. And then tomorrow we also have a lunch for the President and members of the European Economic and Social Committee, 12:45, members' dining room. Can I ask who we think will be able to go from the committee? Chris?
I don't think I'm able to, Chair. Apologies.
Alex?
Denise Derry.
By what date?
Tomorrow?
No,
Anybody from Sinn Féin?
not that I'm aware of.
Unfortunately not. I'm not here tomorrow.
I'm at Police and Board, Chair. Apologies.
So it's just me. Okay. Okay. Also to remind your members on Monday coming, this Monday's plenary, it's our debate on our report on EU priorities for 2014 for all the statutory committees, and it's on the order paper, as you know. Item 3, can we agree the draft minutes of our meeting of the 26th of March, beginning at page 10 in your electronic pack? Are we content?
Yeah, agreed.
Thank you. Matters arising, page 18, we have a response from the department to our request for comment on the negative feedback recorded in the summary of stage 1 of the United Youth Programme Design Day. We've been advised a dedicated United Youth Advisor has been appointed by the department, and that they're going to take all feedback into account as the programme's developed. Any comments or content to note? Take it we're content to note. Page 22, a response from the department giving comment on the paper provided by the Committee on the Administration of Justice on the proposed Equality and Good Relations Commission. The response from the department advises us that ministers have noted the papers and the Committee for the Administration of Justice will be able to submit its views when the public consultation is undertaken. Next to page 25, a response from the department giving us comment on the Carnegie Trust report on measuring well-being in Northern Ireland. This response advises us the department intends to engage with and take appropriate cognizance of the outputs of the round table on well-being that's being convened by the Carnegie Trust. And finally, in this section, members, page 27 is the list of outstanding correspondence. Next, 2 correspondence. Tabled items, page 3, a response from the department on queries on the review of the Victims and Survivors Service. These were raised at our meeting of the 6th of March in relation to funding gaps, the timescale for implementation of review recommendations, and the process of self-certification. I would just say, members, and this is on page 4 of the tabled papers, there does seem to be currently in this interim period a process for self-certification within a Victim and Survivor Service funded organisation It can be done in conversation with a member of staff of that organisation. I have to say, in the face of it, that does not sound like good governance. Members, any further comment?
Well, first of all, I agree with you, but what I find disappointing, Chair, is that the committee spent a lot of time on this issue, much less than the Victims Commissioner and her team did. But all of us have applied a lot of effort to this and shown some better authority than might otherwise be the case. The point of the question, seems to me, was to extract a lot of information, not minimum information. So we were asked further information on the Department's scoping exercise to identify gaps in funding following Piece 3. 6 groups may be affected. The service has consulted with these affected groups to gauge the impact the ending of the funding might have. The issue is what's going to be done, if anything, in the event that funding ends. Question 2, a timescale for the implementation of the recommendations. We get a vague reply. It is anticipated that the majority of the recommendations will be implemented within the next 4 months. The majority? Well, how many is that? And which are they? The recommendations that are going to be implemented? So the purpose of the question was to find out what was the implementation of all the recommendations, when, how, by whom, etc. And yet we get this minimum reply, and that's separate from the point that you make about the process of self-certification. So given the critical nature of this issue and the critical state that the VSS was in, to get answers that say virtually nothing. And I'm affirmed in that view because Mr. Moot referred, or was it Mr. one of his colleagues referred in one of the recent meetings about Dungannon. I received correspondence this week, I couldn't think in great detail about it, where the service is just appalling in terms of the treatment of individual victims, including out-of-state victims. So I just think that we should write black and say this is not adequate for something that's so critical.
Well, I'm certainly prepared, Alex, to go back. I recommend we go back to the department. In fairness, perhaps we opened the door a little bit in our letter by saying we wanted further information on the scoping exercise with regard to Piece 3, rather than complete information.
Well,
so,
lot more questions.
Are members content that we have 3 here, Chris?
Yeah, Chair, no, I agree with what you're saying, with what Alex says as well. The paragraph in relation to Piece 3, I think everybody knows that the inquiry is how is the gap between Piece 3 and Piece 4 going to be filled, and their response, the department's response, says absolutely nothing in response to that question. So it's clear if we have to clarify our questions to prompt better information from them, then I suppose we can do that. Yeah,
well, I think I'll take that one on the chin. Further information does leave it open to providing further but incomplete information. And should probably know better, given
there may have been some obligation there, but that letter is written by a civil servant who wants to say as little as possible when they knew we'd want to know as much as possible.
Stephen, are you content we go back?
I generally concur.
Yeah. Is there anything else, Stephen, you were in terms of Dungannon?
No, not at the moment.
Not until we get the answers.
Yes,
yeah.
Thank you.
Okay, thank you, members. Still on table, page 9, a memo from the Committee for Education requesting a copy of the briefing papers that we received on Bright Start ahead of last week's briefing from officials. In light of the urgent response required in advance of their meeting this morning of the Committee of Education, I agreed to forward the briefing paper to the clerk. I hope members are content with that approach.
Agreed.
Page 10 is a letter from the department with details of promotional events which will be held to encourage applications for the school-age childcare grant scheme, which we discussed last week. Again, content to note. That completes the paperwork, members. We'll now receive a briefing from the Northern Ireland Commissioner for Children and Young People, the Equality Commission, and the Commission for Older People, and this is on age discrimination legislation in relation to goods, facilities and services. Commitment 38 in the Programme for Government 2011-15 is, quote, to extend age discrimination legislation to the provision of goods, facilities and services. And for the record, GFS will be our shorthand from here on. The most recent departmental correspondence was on the 18th of February last, which advised that ministers are still considering various aspects of the legislation, and it would be premature for officials to appear before the committee at this time. However, officials will be discussing potential implications of age GFS legislation with other departments over the next few weeks. In the circumstances, it's proposed the appearance of officials on age GFS is deferred until discussions with departments have been completed, which is likely to be towards the end of April 2014. Now, the panel also includes Mr. Robin Allen QC, who's head of Cloisters in London and specialises in employment, equality, discrimination, human rights, public law and local authority work. Cloisters were commissioned by Nikki and the Equality Commission to provide legal advice as part of their project, which they entitled Strengthening Protection for Children and Young People Against Age Discrimination Outside of the Workplace, Making the Case for Reform. Members, in your electronic pack, the clerk's brief begins at page 31, and that's followed by briefing papers provided by the Commissioner for Children and Young People and the Equality Commission. And following this briefing, we'll be briefed by the Children's Law Centre, and their papers start at page 65. So, we welcome to the committee Patricia Lusley-Moody, Commissioner for Children and Younger People, Michael Wardlow, Chief Commissioner of the Equality Commission, Emer Boyle, who's Head of Legal and Policy at the Commission for Older People, and Mr. Robin Allen, QC. And you're all very welcome. Thank you very much indeed. We would like opening remarks. Michael, would you begin?
Let me just explain, colleagues. Thanks very much indeed for the opportunity. We, as the three commissions, have actually come together to represent a view today about the inclusion of children and young people in the legislation. So I think this is actually the first formal occasion in my 2 years, certainly, where the three commissions have come together to make a point about legislation at this level. And it's because, although we have colleagues representing sectors and we're representing the broad equality legislation, we are not here simply to represent those sectors. We're here speaking because we believe this is an opportunity to address the one gap in where there are grounds in which there still could remain discrimination, and that's age. So we're simply going to have 3 minutes each of us, because we're not going to go through in detail. You'll be relieved to know the briefings you've got. It's simply at the high level, and what we want to allow is that Robin comes in and maybe speaks to the legal issues that were raised and is very detailed with his colleague Dee. And I think you had a summary of that, so you're aware of the background, and hopefully Robin will address some of the issues in that. Claire Keating, who is the Commissioner for Older People, is not in the country, and we had hoped that we'd have Evelyn Hoy, who's the Chief Executive, but she's actually taken ill in hospital at the minute. So Emer has very gallantly stepped in and has taken forward the presentation on behalf of the Commissioner for Older People. So thanks very much, Emer, for doing that.
Yes, thank you.
I just want to say some very, very briefly, 3 or 4 points. I think the first thing is that human rights are universal, and therefore fundamentally equality applies to all ages. So we wouldn't see that there should be any precedent to say let's have this legislation with a cut-off point at 18 any more than in any other form of legislation it would be acceptable to have an age restriction. So why should there be an age restriction on the goods, facilities and service? Ties into European law and the other things that we have on our presentation. Children and young people, we recognise, are in stages of development, and between the ages of 10 and 21 there are about 30 different stages that you pass through, none of which say I'm an adult from here on in, so we recognise that. So why pick 18 as a transition age? There's something in there, I mean, whether it's 16, 18, the question for us is this should be cradle to grave in that sense. Children and young people are protection, but special protection is better than no protection, we would argue. And the commitment that the Executive and Assembly have is to improving the lives of a lot of young people. We believe this plays into it. Now, we've made cases and there are specifics around how children and young people receive, in some cases, poor provision in health and social care, poor provision in terms of education, and we can fill those out if that's necessary. But more than that, this actually says something to children and young people about who they are and what they are. They're not the future, they're here, they're the present. And we're not advocating for them, we're standing with them. And we're actually saying this is about building their confidence. It's saying they matter, saying that we're concerned about their well-being. And by offering protection that only starts at 18, I think there's a mixed message going across. Section 75, although it doesn't apply to the Assembly, helps to dictate the parameters in which public bodies should be taking decisions about how they follow policy implementation. In other words, it's about good practice. And we'd be suggesting, therefore, if you're looking at Section 75 in its broadest, if not legalistic sense, that then to exclude children and young people when it's one of the protected groups' age would seem to set that apart. There are some concerns we're aware of, and Robin's going to address some of them. But I would say from the outset that this legislation, if it comes through, will not set children against parents. They will not see children divorcing parents or children taking cases to court. This is actually about empowering parents and empowering families, and more of that again from Patricia and Robin. People have said, well, what about parity? What about us taking this on? If you followed the debate within GB, actually, there wasn't a lot of time for discussing the issue about children and young people. There was an ageing population. By 2018, older people will outnumber younger people. That's not the case here. We're one of the youngest populations in Europe here. The second thing was the power of the grey pound, and there was a very strong argument about money and spending power. And why should money be something that dictates whether people receive goods, facilities and services? We think there is a case here. But anyway, we have Australia, Belgium and Canada who actually have gone before us in this, and there has not been a plethora of cases end up in courts. In fact, to the contrary, it could be argued this strengthens the nuclear family unit. And I think finally the big one is the law of unintended consequence. This legislation will not overrule, override, set aside, be in contradistinction to the existing protections. If we are able to have existing protections there, that means we have the intelligence and the ability to do it in the future. This will come alongside it, but it should be able then to take a child's age into account only when there is an objective reason to do so. For example, a child can buy moped insurance at 16, ordinary insurance at 17, can take on travel insurance on his or her own right. We're not saying they should be able to walk in and get alcohol at 14 or pick up a gun. And I know these are very emotive things. We can build in the safeguards. We already have those safeguards in. None of those will be set aside. And I think, there are some issues that I think particularly maybe Patricia and others might raise about issues specifically young people that are around the age, whether it's the use of mosquito devices or asking kids to leave their bags outside a particular supermarket in order to allow them to gain entrance. Those are issues that I think would be then taken into consideration. Where is the evidence base for this to happen? Is it simply because of age? And finally, this is not going to be the panacea. This will not mean that all children get good health or education care. This is not about this. We've never said that's the case. But it does mean age cannot be the discriminatory factor brought in without an evidential base for that. It will no longer be enough to say you're too young to have that protection. We actually think in a modern society that's not an acceptable defence. So I'm going to ask now my colleague Patricia to pick something up, and then Emer, and then we're passing over to Robin. Thank you.
Can I begin by thanking the committee for hearing me here today? And initially I tentatively welcomed the Northern Ireland Executive commitment in the programme for government, as we've talked about, to develop and consult on the proposals to extend age discrimination to cover the provision of goods, facilities and services. And I welcomed it on the basis that I believe that it would deliver protection and therefore equality and greater equality for people of all ages. I understood that children and young people would receive the benefit of this protection, which is in accordance with the government's obligations contained in the United Nations Convention on the Rights of the Child, or the UNCRC as we know it. And the UNCRC is clear on this point. And Article 2 contains one of the fundamental principles of the Convention, non-discrimination. So I am extremely concerned that children and young people may not be included may now be excluded from the protections that this legislation could offer, and that if they are discriminated against on the basis of age, they will not be able to seek an effective remedy under the law. Including children and young people in this law would send a strong message that this Assembly and this Government actually value them as citizens. And the UNCRC Committee has previously expressed concern at the general climate of intolerance towards and the negative stereotyping of our children and young people throughout the UK. Excluding children and young people from this proposed law will do nothing to dispel this view. There is very clear and compelling evidence that children and young people are currently subject to less favourable treatment and harassment because of their age when accessing goods, facilities and services. And I can give examples of this. The issue of children being accommodated on adult mental health wards is one which you will no doubt be aware of. I am aware that children and young people continue to be accommodated on adult mental health wards, and while I welcome the work that has been done to decrease these admissions, the problem still persists. Children and young people, especially those who have additional vulnerabilities due to mental ill health, require additional protection, not no protection. There is a clear parallel here between the experiences of children and young people and older people with additional vulnerabilities. Complaints to my office highlight that children and young people feel that they are regularly treated unfairly because of their age when accessing shops, unfair treatment which they consider is based on negative and prejudicial attitudes towards them because of their age. And the ARC Young Life and Time survey in 2010 revealed that 83% of young people believed that they were judged negatively simply because they were young people. Two recent complaints that we've had to our office at this point was a 16-year-old who's a member of a local gym contacted us as he was told that under 18s weren't allowed in the gym between 5 and 7:30 so that the adults coming from work could use the facilities. He pays the same fee as the adults, but he believes his use of the gym has been restricted without good reason, whereas adults' time have not. Another was a 16-year-old complained to us that she had been treated poorly because of her age in a local shopping centre. She had saved up money to buy a present for her mother in a jewellery shop, but when she asked to look at some of the goods, the shop staff were rude to her. She felt that because of her age, they assumed that she couldn't afford to buy any of the items, and she was told to leave the shop and was actually escorted off the premises by a security guard. So, if the law were to be extended to include under 18s, then the actions of these service providers, in the absence of justification, would be likely to be unlawful. If under 18s are not included in these, young people would have no way of challenging these service providers. And I am aware that there are a number of MLAs have raised concerns that including children and young people in this law will impinge, as Michael has said, on the rights of parents. It won't. Giving children and young people protection under this proposed law will benefit both children and young people, their parents, their guardians and their carers. Far from diluting the parental authority, this law would enhance a parent's ability to ensure that their children receive appropriate services on a non-discriminatory basis. Children and young people already have rights against unlawful discrimination when accessing goods and services on other equality grounds. So parents exercise these rights on behalf of those children to ensure that their needs were met by service providers. Parents regularly use the rights of disabled children that disabled children have under disability legislation to ensure that reasonable adjustments, for instance, are made by schools for their children, or to ensure that appropriate provision is made for their child's special educational needs. Concerns have been raised in the Assembly that the legislation could mean that parents may become the subject of litigation by their children and that the requirement for parental consent would be undermined. Again, this is not the case. The law would not allow children to litigate against their parents. Only service providers can be litigated against. Recognising children and young people under this legislation will not undermine parental controls or authority or undermine the requirement for parental consent. Including children and young people in the extension of this law would be consistent with the Executive's commitments under its current children and young people strategy, which is designed to improve outcomes for all children and young people. And I believe that our recommendations are also in keeping with the Executive's proposals to include or to improve the lives of children and young people through delivering the social change framework, and are consistent with the Together Building a United Community strategy, wherein children and young people were named as a key priority. Including children and young people in this legislation will improve outcomes for them. It will improve their health outcomes by ensuring greater access to age-appropriate health and social care services, including mental health services. It will build their self-esteem and confidence, and by helping to build a society that respects our children and young people's rights, and it will enhance their ability to live more independently through removing unjustifiable barriers to accessing financial services and accommodation. Thank you.
Thank you. Commissioner Wardlow has already spoken about older people in his presentation to you, and I wish to affirm that the Commissioner for Older People is wholly in support of goods, facilities and services regulations that afford protection to all age groups, including children and young people. As well as this legislation being a programme for government commitment for the Department, the recent consultation on the active ageing strategy and its associated action plan affirms the Department's goal to bring protection from discrimination on the basis of age into law. The Commissioner is concerned that unless agreement can be reached on the scope of these regulations and the formal consideration commenced, that this Assembly will run out of time to bring them forward. The Commissioner understands that officials in OFMdFM have been tasked with the ongoing development of drafting regulations, and she welcomes that activity so that when agreement on the scope of the regulations is reached, the work will be well advanced. Older people make complaints to the Commissioner that they are or perceive themselves to be treated unfairly on the basis of their age. The types of complaints received by the Commissioner's office relate to a wide range of issues, from pensions, the inability of older people to secure insurance cover, the removal of specific types of social care on the basis of a person's age. And research across Europe suggests that discrimination on the basis of age is increasingly widespread, including services such as finance, insurance, health services, mortgages and loans. It was recently reported in research carried out by Queen's University Belfast that older people suffering from cancer are receiving less favourable treatment for the disease on the basis of their age. This type of discrimination is inexcusable. What is required is a strong legislative framework with clear enforceable rights for older people and indeed for people of any age. The Commissioner believes that older people must see legal protection from age discrimination delivered through this programme for government. The Commissioner is aware of concerns from some parties that allowing the full continuum of ageing to be represented may interfere with or in some way diminish parental authority. In fact, as you have heard from the other Commissioners, this is not the case. Parents are not service providers in the sense of this legislation, and their behaviour and authority would not be adversely affected by the provision of protection from discrimination by these regulations. It is much more likely that parents will use the regulations to strengthen the argument for specific, age-appropriate treatment for their child or young person from public authorities and private service providers. The legislation can provide for differential treatment on the basis that it can be objectively justified. And in other regulations of this type, this has proven very effective. Although the Commissioner for Older People's statutory duty is limited to speaking on behalf of issues relating to those over the age of 60, the Commissioner is concerned that legislation that seeks only to afford adults with specific protections from discrimination cannot, by its very nature, be considered to be equality legislation if it also ignores the rights of the children and grandchildren of those adults. Throughout the Commissioner's recent programme of engagement directly with older people, she has not encountered any older people specifically calling for protection from discrimination to be limited to older people, nor of any older person calling for children and young people to be excluded from the legislation. The Commissioner is concerned by the risk of critical issues such as the scope and application of this legislation being ultimately decided through potentially avoidable and time-consuming legal challenge. It is surely preferable for the legislature to decide and define the scope of the regulations at the outset. The Commissioner for Older People has been heartened by the evidence in Mr Allen's opinion that in countries where legislative protection against discrimination on goods, facilities and services has been extended to children and young people, this has not resulted in the unintended or undesirable consequences that those resisting this legislation fear, nor has it resulted in excessive litigation. In fact, a survey of MLAs undertaken in December 2013 by Stratagem Comres MLA research panel suggests that there is considerable support for legislation protecting people of all ages from discrimination on the basis of their age. 79% of MLAs surveyed believe that GFS legislation should apply to people of all ages. And that was broken down to be 85% nationalist and 75% of unionist MLAs on that survey. In light of that evidence, all three equality bodies now call for the parties to allow a free vote in any forthcoming debates and decisions regarding the legislation. The Commissioner calls on the Ministers and the Legislative Assembly to adopt best practice and legislate to the highest international standard by including everyone in the scope of the proposed regulations, regardless of their age.
And that's
Thank you.
our sort of short, hopefully to the point, which we're speaking from one voice. And hopefully, Robin, if you can indulge us, will allow maybe to focus on some of the legal and maybe offer some things to think about how we might progress this. Robin.
Thank you very much. Chairman, members of the committee, thank you very much for allowing me to make a contribution in relation to this. As you've already heard, myself and a junior barrister in my set of chambers, D Masters, BL, were retained by the ECNI and Nikki to draft a legal opinion to set out how this kind of legislation might work, and indeed to explore why it should be considered. And we were delighted to do that. And there is now in the public domain our opinion, which is long and very detailed. And I'll say a word or two more about that in a moment. But I would like, if I may, without, I hope, sounding as if I'm blowing my trumpet, to tell you a little bit about my own background, because what I hope I can add to this debate is some technical expertise in this area of law. Now, I've actually worked with all the UK Equality Commissions for getting on for 40 years. I first started working with the Commission for Racial Equality in the mid-1970s. I've worked with the FEC when it was in existence in Northern Ireland, and the Northern Ireland EOC, as well as, of course, the ECNI for some 20 years. And I was also involved by the European Commission to advise them on the drafting of the two directives which are so important, the Race Directive and the Framework Directive, which deals with sexual orientation, religion and belief, disability discrimination and so on, and gave them initial advice on how those directives might be drafted. So I do, and I should add to that, I was retained by the Equality Commission in London to advise government and it about the text of the Equality Act 2010, which is the GB legislation in the field of equality. So I do know a little bit about how equality legislation can be made to work, what the difficulties can be, making sure that legislation is aptly predictive, how it's effective, and how it is something that advances society and doesn't retard it. And working with Dee, we've tried to bring that experience to bear on this particular problem. Now, I want, if I may, to just provide one short piece of focus. Who around this room, let me ask this rhetorical question, would permit in a society in which they were a politician there to be discrimination between men and women, boys and girls, in the provision of goods, facilities and services? Would you permit a society in which the provider of services could say, we'll give it to women, we'd give it to girls, but we wouldn't give it to boys? It's laughable. It is a laughable proposition. That is where our society is. What we've got now is a law in the GB which permits people to say, I complain because I'm not being given goods, facilities and services because I'm over 18, but I can't say that if I'm under 18. There's a total lack of logic in it. It is a provision which itself is discriminatory, as written in GB. And you needn't just take my word on it, because the Joint Committee on Human Rights, the Parliamentary Joint Committee on Human Rights, has said exactly the same thing, and we've pointed this out in our opinion. So as a matter of straight logic, to exclude under 18s from a law preventing discrimination on grounds of age is mad. It's not logical. Nobody could stand up in a debate where logic was the test and say this was a good thing to do. It doesn't make any kind of sense. On the other hand, I do recognise equality law and new equality laws have got to march hand in hand with the way in which society is developing. And that's really important. A law which tries to get ahead of itself will not garner support from a community and will not be an effective law. And we've tried to address that point specifically in our opinion. And we've done that by saying, look, there are other countries which have these laws against age discrimination that work both above and below the age of 18. They exist in Canada, they exist in Australia, and they exist in Belgium. And those are three very different societies, quite different legal traditions, civil law country and common law countries. And they work. There is no evidence that they have caused difficulties. And that's because the lawmakers in those countries have engaged with some of the issues that no doubt will be worrying politicians in Northern Ireland when they listen to these proposals. Can I say a word or two about those issues? Firstly, nobody is proposing, and I'm certainly not proposing, legislation which should tear up the wisdom of legislators about the need to address the vulnerabilities of young people. Young people are vulnerable, and those vulnerabilities are addressed in laws such as saying you can't get a driving licence as a provisional licence until you're 17, you can't get firearms until a certain age, you can't have sexual relations until you're 16, and so on. Those laws are a given, and it's not proposed that those should be changed. The purpose of the law that is being advanced or suggested to you is to fill the gaps and to say where there isn't specific provision, there's a general proposition that those that deliver goods, facilities and services, whether in education or housing or commercial services or in health, the general rule is that you do not give less favourable treatment just because somebody is of a particular age. You may, and we recognise this, give positive action because you think somebody has a particular positive need, but you do not give less favourable action just because somebody has a particular age, unless there is an objective justification. Now, we recognise, and we've said so within our opinion, that society moves on and we may need to create new exceptions. And we've suggested that there should be a power within that legislation to anticipate in the future that new exceptions would be necessary. But the starting point is to take society as it is and to fill those gaps to ensure that just as you couldn't discriminate between a boy and a girl in the provision of healthcare, you couldn't discriminate just because of age. You couldn't discriminate presently on grounds of political affiliation of their parents in delivery of healthcare or education. Can't do that. Equally, you shouldn't be able to do it on grounds of age. Pure logic. Just filling those gaps. I know, because I've been involved in some of these discussions, that these suggestions take a little bit of time to get used to. And that's common whenever anybody talks about developing equality law. It's completely natural. There are some myths going on that I've heard discussed. Suggestions that this would allow children to divorce their parents. This is truly a myth. It's got nothing to do with that at all. Parents do not provide goods, facilities and services to their children. They don't engage with this law. Anybody who thinks that that's what this is about needs to leave this room in due course to know it isn't. That's not what we're talking about. And I think that's an important point. I know from talking to the three commissions that they would want to engage with you politically to make sure that those myths are understood to be myths and put to one side and are not a cause for worry. Every politician looks over their shoulder at those who've elected them. And if those myths do exist out there, they need to have their answers for them. But the answers really do exist, and they shouldn't be a worry for you. But I think it is important equally to recognise that all too often, and we've heard some of the examples of this in, for instance, the delivery of healthcare, there are assumptions that you cannot look at the individual, you can simply look at their date of birth, and on the back of that, decide you'll do this or that. One of the really beneficial outcomes of equality law is it truly dignifies people. Sometimes people choke at the idea of giving rights to people, and you can put that kind of language to one side and see this as treating people as individuals. So it's about human dignity, about understanding what it is that makes a person the particular person who's in front of you. If they have a need to a particular healthcare provision, you don't deny it just because they're too old. You don't, for simply administrative reasons, say you'll have to wait another year before you can have a benefit that you really need now in a particular delivery of service. And I think that one of the real reasons for actually praising the three commissions for bringing this proposal forward to you is the outcomes that you can expect by getting more appropriate treatment for individuals in healthcare provision, more appropriate treatment in terms of education, and indeed more general equal treatment in service delivery. Can I bring us back to this point of logic?
Sean, I'm sorry to interrupt,
Yep.
but we are keen to question you.
Fine. Well, then let me draw to an end at this point and say I'm more than happy to deal with technical questions about this and to field them. And I will certainly say that much of the detail of that you will find in the opinion, which is available to you.
Yes, and members have that in the pack. Thank you very much. Thank you to all of you for your presentations. Before we get into the detail, and there is much, I think, to explore, members, I suppose to look at the legislation. First of all, there are two issues, I believe. One is the programme for government commitment, and secondly, there is the extent to which that commitment has been advanced as per the timeline set out in the programme for government. So under priority 2, I think the key phrase is the intention to extend age discrimination legislation to the provision of goods, facilities and services. And there's a question mark as to whether that is for older people or for everybody. And that's a discussion. The second issue, which I don't think is unrelated, is the speed at which it's coming forward. The milestone for financial year 12-13 was to develop and consult on the proposals. For the year just gone, 13-14, it was to progress legislation through the Assembly, and in the current year to complete the legislation. When we were last updated at committee, which was recently, we were told that there was an expectation or a desire to bring forward legislation by June. However, if we assume that they're going to allow for a full 3-month consultation, that cannot possibly happen, even if they start today. And according to the OFMdFM website, they're still scoping consultation. So can anybody update the committee as to their understanding on the timeline?
I think it's fair to say that in the first instance, the 2011 commitment, it was never our understanding this was restricted to 18 plus. This has happened post-event. Now, there may have been a political disagreement on that one, but certainly from our end, we had seen what it said is what it said on the tin. So this was about age discrimination right across. In terms of then tracking this, we have been sort of diligent, all three of us, trying to say, I mean, young people who would have been excluded are going to be no longer excluded because they're now 18 when this started, because they were started at 16. So there's a sense in which time is against us, but we've got to get it right. Time isn't the only thing, and yet time is important. We're saying we need to get it right. I think the concern I have is 3 years almost on, some of the myths still exist. Now, to bust those myths is important, but this isn't within our remit and gift. This is also within the gift of politicians and those in civil society. So there's something, and Robin said, about how do we bust the myths? Because as long as myths perpetuate, people then can stand behind them. The MLA survey is actually very strong. It's 70% plus of MLAs. There's cover within the Assembly, it seems to me. Certainly our experience and scope in this is people would like this to happen. So in terms of where it sits, we understood, first of all, it might have been ready to go for consultation towards the tail end of last year. But now, will there be 2 consultations with it over and under 18? Will there be one with options? To be frank, I'm really sorry, but we don't know.
So what do you believe has happened since the Programme for Government Commitment was published?
I think there's been a lot of talking, but not a lot of doing, to be honest.
Talking about what?
Well, talking about excluding or including or the whole issue around the legislation. And my understanding in the conversations that I've had is that when we talked about GFS, as Michael has said, that there was never any talk that this would only be about over 18s. And certainly talking to older people, that was not their interpretation of it either, even though they may have been very vocal around ensuring that this happens, and it was in the programme for government and they welcomed it as we did. We assumed that it would cover all ages, and it's only as it's coming up towards the period of when we thought this consultation was going to happen that all of these issues started to arise. And so therefore, as Michael said, we have been very vocal in meeting all kinds of people and the department and the junior ministers to make it quite clear that collectively as bodies we want to see children and young people included in this legislation.
I think positively, Chair, we're not finding any party saying that young people shouldn't be included. But what we are hearing is how it's done and when it's done. And those are 2 different things. Yes. So we could argue forever around the forensic of this, about all the examples, and everybody could nod and say, isn't that great? But we're faced with the question, is this now the right time to do it for everyone? Or are we somehow saying we're going to take this forward sequentially? I can't see the logic in the sequential approach, because you wouldn't say, well, we'll include men in anti-discrimination legislation now, and if it works, we'll include women next year. Now, I'm being flippant in one sense, but I'm saying there is no logic in this. If we have to build trust, we're 3 years on. So what more trust do we have to build in this one? So I think what we're saying is the forensic arguments have been advanced. This is a question of, is this the right thing to do? And we're saying it is. Is this the right time? And we believe it is. And
can I just say on behalf of children and young people, they have said that if the roles were reversed and they were being asked to support legislation going through that excluded over 18s, they wouldn't stand for it either. They would stand strong for the inclusion.
Well, somebody used the expression myth busting, I think.
Yes.
I think that is important, Michael. I just wanted, there was one thing you said in your presentation puzzled me. You said we're not advocating for young people, we're standing with them.
Yeah.
But if I read the legislative basis for Patricia Loosley-Mooney's position, it is to safeguard and promote the rights and best interests of children and young people, and the same would apply to the older Commission legislation. So actually you should be advocating, not standing.
I think the difference is I am not simply here talking on behalf of young people. We are actually advocating alongside young people. That's the point. Because for so often it's adults talking on behalf of young people. Young people's voice has actually been heard. So the evidence base in which I'm bringing to you isn't simply me saying this, that's the point. We're saying this on behalf of, but alongside, as opposed to simply picking this out of an air because it's in an operational plan or business case somewhere. We're united in this is evidence-based.
Emer, you made some powerful testimony, not least in terms of medical treatment for older people, but are you basing this entirely on principle, or at any point do you make an allowance for pragmatism and practicalities, such as the fact that resource within the National Health Service, as we hear on a daily basis, is finite?
Well, that's a question I would probably like to take back to the Commissioner to get her view on, but it would be both. You know, I could justify an answer that would be a pragmatic approach, but really the point of us being here today with the other commissioners is to stand together and to really try and help political consensus to be gained on the matter of legislating from cradle to grave.
That's because I get the point which I think Patricia made in terms of, say, a young person in hospital for a protracted period in an adult ward. I made a television programme once on cancer charity, and one of the people we featured was a young woman who had to spend time in an adult ward, and that was really depressing for her, that there was no peer for her to talk to. But there is a question of resource. So can I ask the question, is it principle or does principle? Because you did make reference, I think, to objective justification.
Chairman, I'd really like to be able to contribute on this point, if I may.
Yeah, sure.
The interface between equality law and resources is not virgin territory at all. It really isn't. And it's not virgin territory in the context of age either. I've personally litigated it in the Supreme Court as an issue. And the rule that the Supreme Court has said is very clear and it's very simple. What you can't do, consistently with human rights principles, is to say that simply on grounds of cost we can't give equal treatment. What it says is that politicians and administrators can set budgets. There is only a limited amount of money for education, for health, for a sector in health. But once you've set that budget, the rule should be that you should have equality in the distribution of it. Now, that doesn't mean that you give exactly the same amount of money to each age, but you've got to have a justification for why you give it to different people. You can divide up that budget according to equality principles. Now listen, if you pass a law which starts at 18, you're going to have that rule applying between 18 and when people die. What is the logic in not having that rule from 0 to 18? I can't see it. There isn't any. The budget is going to be the same. You should have the same rules applying as to what is equal treatment in distribution of resources within the whole age range. That's the position that I would put forward.
Okay, that's useful. So I can understand that, Robin. Let me take it a little bit further to an extreme example.
Yeah.
Let us say my 19-year-old son. Okay, so 19.
Just over the mark.
Yeah, so he's over the mark. So he's 19 and I am beyond 19. And we are both involved in a very serious accident, and because of the medical circumstances, the doctors can only save one of us. I would want my son saved, because I've had a life, and he hasn't. Is that discriminatory in any way?
Well, if you say, I give my place up to my son, of course it wouldn't be discriminatory because you wouldn't be a victim.
But I haven't had the opportunity to say that because this has happened.
No, but realistically it works in a different way, doesn't it? What happens is that both of you would be taken to hospital, to the infirmary, and the doctors would then have to decide what the treatment is that would be necessary for both of you. And they shouldn't have to make a decision on the basis of age in relation to them. The decision should be, with the money available, what can we do? That's the way that it should be dealt with. Of course, either of you might be able to say, I defer to my son, or the son could say, I defer to my father. That's a question of choice. But assume both of you have lost your power of speech for one reason or another, the doctor doesn't make that kind of division. And if I may say so, this is not new territory. Doctors at present, are held up to challenge in relation to do not resuscitate notices. They are. And there's established case law that deals with how that's to be dealt with on a non-age discriminatory basis.
You used an expression of objective justification.
That's right.
Is that well defined, or
absolutely?
Is that...
Yes. This is standard equality case law. Essentially, what it means is that you've got to have a legitimate aim. You need to know what you're doing. why you're doing it, and then you need to take steps towards that aim which are truly proportionate to it. So they've got to be appropriate and reasonably necessary for achieving that aim. That's what an objective justification is. And that, if I may say so, that's something that happens all the time. It's been in process, that test, for many years now. I'm sorry, I interrupted you, Chairman, I didn't mean to.
No, you're okay. It's within the context of less favourable treatment. It's not acceptable unless there is an objective justification.
Yes. Could I give the example of free eye tests? I mean, the government could say we'll give free eye tests to over 60s and we'll give free spectacles, for example, to under 6s, provided that went through the normal due process of law. It wouldn't be set against because of some equality legislation on age. So you can actually legislate for specific government intention as long as they have an intent and they're objective and they're set out with an appropriate end. But you couldn't say all left-handed people under 6. You know, you need to have a reason for it and be able to justify that within your government policy. It already exists.
A good example of this might be chlamydia testing. Now, chlamydia is a sexually transmitted disease. And you wouldn't want to have a policy, for instance, for chlamydia testing at an age when there's no real expectation of young people having it. But as soon as you think they might be sexually active, you will want to have a policy which provides for that. And it would be objectively justified to do that. Your aim is to get rid of this sexually transmitted disease, to identify it, to treat it, and so on. So an age-based rule could be objectively justified in a context like that. It's a very good example of it.
Okay, just before I open it up, one more if I may, which again falls to yourself, Robin. I think you said parents do not provide GFS to children.
No.
What if a parent said to you, but I give my child an allowance? Pocket money to a certain age group.
That would ordinarily be a gift, wouldn't it? And that would be the way it is. I mean, it's not what GFS is concerned with is social goods, the provision of housing, healthcare, and so on. Services such as financial services or services in relation to healthcare, educational services, commercial services, classically. And so on. So that's what is normally held to be in scope with GFS. It's not normally. I know of no case at all in which, for instance, a child has said, "You've given the boys more money than the girls," suing the parent. That sort of argument. It doesn't exist in the sex context. I'm so sorry.
Stopping the allowance?
I know of no case of that kind, and I don't think the courts would entertain it under current equality laws.
I live in a 3-bedroom house. I'm married. I have 2 children, so they have a separate bedroom each. My wife becomes pregnant. I say to one child, "You're going to have to share."
I wouldn't see that as being in scope of the legislation at all.
It's not commercial.
It's not commercial. It's
circumstances. It's up to the family to make a decision and choice on that.
And I don't. No.
Okay.
This is not a law which is. I mean, there are other exceptions. I should tell you, there are other exceptions in equality law, and historically there have been. They've been, to some extent, contentious about what happens within households. I mean, when the race discrimination laws were first introduced, you know, people thought that they'd be forced to provide bed and breakfasts for, you know, or have paying guests, and they didn't like people of colour to be there, and there were exceptions in relation to that. And now, I'm not suggesting you need to do that, but essentially there is private space and there is public space, and this is a law which is not concerned with the private space within the household.
Okay, Bronwyn McGann.
Okay, thank you, Chair. Thank you for your presentations. And I'm a mother of a 17-year-old. And for our part, we want to see this legislation cover all. And we are prepared to work with all political parties and stakeholders to deal with these myths surrounding all of this. Can I ask, what assurances can you give to those people out there who feel that this legislation could potentially undermine parental rights?
Well, I hope that what I've just said may do in part that. But I think perhaps I can deal with it in this way. you are governed by the European Convention on Human Rights, which contains within it Article 8, the protection of private and family life. And this legislation would not be concerned with interfering with family life. That's a different, as I say, it's a different legal space that we're talking about. Parents have to make decisions about how they treat their children when they have parental responsibility over their children, which is the norm. One parent or another parent or both, depending on whether it's a nuclear family. That's just not the legal space we're engaging with. It's what happens outside the front door, bluntly.
And can I say, you know, in my presentation, I talked about not taking away for parental rights. This is actually enhancing parents' rights by giving them more tools in their box when they come to argue for their children whenever the services that they're needing, they're not getting. So it's actually enhancing parents' rights, if you like, for the want of a better word, by giving children their right and to use this legislation in order for parents to be able to make the argument. So, for instance, the parent of that child who was escorted off the shopping centre, when they phoned up and asked why they did this to their child, there may have been a mediocre apology. But at the end of the day, if this legislation was in place, then there would be the opportunity for those service providers to sit up and actually take notice and say that we can't treat young people in that way.
It also obtains in special educational needs, where we have a responsibility if someone comes and feels a child's not being treated appropriately within the educational sphere covered. And children don't come to us, it's parents come. And if your child was badly treated, you as a caregiver, parent or otherwise, would want to advocate and stand with that child. And this is one of what we're trying to say is there are myths that exist. Children are going to run and get credit cards and run amok. Kids are going to sue their parents. What we're saying is in the 3 jurisdictions where this has happened, that has not happened. And because of the protections that are afforded by the international treaties and the limitations of this law and existing legislation, this complements rather than challenges. And in fact, in my argument, would empower a family. Because at the minute, that parent has no redress. An 18-year-old has a redress, but a 17-year-old brother or sister may not have the same redress to have the same thing happen. That seems to me to be a bit bizarre.
And in fact, when the parents come to us around these issues, they're kind of taken aback that children don't have this protection.
Can I throw in my 2 pence to add to that, which is that it is a well-trodden path in the field of equality law to have a code of practice that works alongside the legislation. And there's absolutely no reason at all why, if the Assembly, for instance, was to adopt this legislation, it could say expressly on the floor of the Assembly, we expect the Code of Practice to say something like what you've just put forward, could be put in the Code of Practice, and so you'd have the double comfort of, A, what I've said the legislation means, but more importantly, the Code of Practice would say explicitly that that's how it works. It could be done perfectly easily. Yeah. That would be a normal way to deal with these sorts of problems.
Well, for me as a mother, I'm absolutely reassured by everything that you're saying, but for me, it's fundamentally an equality issue.
Well,
we've
convinced you anyway. We're very, very happy to field any other concerns that there may be from other members of committee.
Yes. Alex Maskey.
Thank you, Chairman. I'll make a couple of comments, questions, but I have to say, Chair, I thought some of the earlier questions were bizarre, actually, and I mean, if you ask somebody from an older person's Commissioner, could it justify on resources basis not giving treatment to an older person? If somebody gave me a positive answer to that, I'd want them out of the room, to be quite honest with you.
Well, they're my questions. You can call them bizarre, but they're mine.
I'm just making a point. I just think that the matter is important, and it would be better to examine if there are any adverse reasons for applying this legislation. I, for one, and me and Brom has already made the point, certainly from where we're coming from, we just can't see a logic of legislating for anti-discriminatory measures. In other words, to bring in anti-discrimination legislation includes facilities and services and then discriminate against a certain section of the population, because that's in effect what we would be doing. I do think it is important that we do try to identify what are the myths. I do think it is a bit unfortunate, which is really my point, that at this stage again people will still be subjected to some of those myths, which are really a wee bit rich. But nevertheless, where we are at the moment is we do have an issue around people would have concerns, legitimate or otherwise, but they do have concerns. So for me, it's how do we take those concerns down? I do appreciate you're here today to make the effort and to explain the committee and to try to allay those concerns, because clearly some people do have concerns. Would it impact on parental control and family unit and so on? I don't have any problem with it. I think the legislation is quite circumspect in its own, in the terms that it would be there, so I don't have any concerns about it. Recognise if others do, then they need to have those questions addressed. I want to thank yourselves for making yourselves available to present that evidence to yourselves and to commit to work with us to bust the myths continually if that's what needs to be done. I'm certainly assured by what your presentations have been so far, and I'm sorry I missed the earlier part. But in terms of, I think you actually, I can't remember if it was Emer or whoever, maybe Michael yourself, just passed the point when I was here around the issue of the no logic in terms of doing this incrementally. I don't see any logic ever bring a bill in and bring it in, end of story, given the fact that it is rather circumspect at the end of the day. So I just want to tease that out again. I mean, I don't see any, so I'm not advocating an incremental approach, but I think one of you did refer to it earlier.
Well, the reason I did was simple. I think what I said, Alec, before you come in was that my read of this is that the parties are agreed that this should be from cradle to grave. What I'm hearing is a disagreement about how, the mechanism and the timing, two things. So I guess what we're saying is it's not to be convinced that this is needed, it's why do it now than later. And one option is we do it at 16 or 18, whatever the age we choose as a transition point, and somehow we allow trust to be developed to show that there aren't the law of unintended consequence, and then introduce it later, sunset clause or something. I'm not sure what that does, because it still doesn't address the issue of the under 18s. And how can we use that period of protection to further build the trust that we've been trying to do for the last 3 years? So if I thought genuinely there was some reason to retrieve this in a 3-year promotional campaign, I would be for it. But we can't see any justification for it, and therefore we feel, if you believe it's, grasp the nettle and go for it now.
I think, just to we follow on that, I mean, obviously, you know, parties will make their mind up and come to this from a party point of view in terms of policies. Our difficulty in this is that there's a wee bit of a potential to emerge some people from the older sector of our community, and some of us are hitting that themselves. But, you know, one of the choices but some people have been putting to us, for example, privately, would be, well, we have a legislation which will cover older people at the minute, and if we don't, we'll have nothing. Now, I think that'd be a very unfortunate territory to get into, because it then starts to divide people, and people would obviously be arguing, particularly from an older point of view, well, I mean, time's less than it might be for a younger person.
And can I just say, I think that was the importance of the three organisations being here today to show that we're united on this. You know, we're worried that people out there think that there is the opportunity to divide and conquer. And it goes back to that issue of, as Emer said, that any older person that has been spoken to certainly would want the inclusion of younger people. And on the other side, as I said, if this was about younger people and excluding older people, young people would stand firm to ensure that older people were included. So, and the other thing that I would say, and the questions that I've been asked, is that if there are myths out there, what are those that are listening to the myths doing to dispel them? You know, we've given everybody the arguments around all of the issues that they've raised around the myths. Why are they not using them to dispel them? And they can't answer.
I think, in short, Chair, we're saying this is an opportunity not to be first, because I know that some people there's fear, but we have been first in other things in this place. But we already have Australia and Belgium and Canada have done this. We have hopefully addressed some of the myths. Now, I understand there is a trust issue, there's a method of how you legislate. I think what we're saying is now, you know, time isn't in our favour, but time shouldn't be the only thing that we use as an expedient, if you like. But there's no argument to delay this.
Okay.
So can I be clear in terms of what you and Patricia have just said, in terms of let's get on with it, the ammunition's there, the argument's there. Are you saying get on with the consultation?
Yes.
Absolutely.
Yes.
Okay.
Can I just mention a word about the 16 proposal that some people have put forward? It inevitably has a superficial attraction, saying that we're a bit worried about this law, so let's not go too far too quickly. But you can test it in a very easy equality framework. For every other equality right that exists, if a black person wants equality with a white person, they have to concede that the white person has equality with them. if a woman wants to have equal pay with a man, the man has to concede equally that he too should have it the other way around. This is the one area that, it's unique in the debate to hear it suggested that older people should have equality rights, but it shouldn't actually operate entirely the other way around. It doesn't make sense. If you see it through that lens, you can see why it is that this doesn't really work in that way.
Well, presumably the one argument is this argument of young people maturing. But to pick an age is random.
Well, that's an
Why
argument,
16?
transition. What point?
I mean, and as Michael said, we range from 10 to 18 or 21 with 21 different types. So why not pick 10, which is the age criminal responsibility? Why pick 16?
Of course.
I think we're simply saying we understand the fact that that there's something around trust here. There's something about, I don't know what this thing looks like. I think we've gone as far as we can to say we hope we address those myths. But there needs to be a step of trust here to say the legislation is there, and I'm not sure what else we can do to give you that assurance. We've offered briefings, we've offered all sorts of stuff, and I think what we're saying today is we're presenting a united front. If there's anything else we can do to try to dispel some of the concerns, we're not saying you're wrong to have concerns, by the way, please don't take that.
No.
We understand those concerns. I'm a parent as well. I know what it's like if you think your 14-year-old's going to go on a wobbler or something, but this is about empowering families and building up the esteem of young people.
Stephen Mitry.
Thank you, Chair, and thank you for presenting to us today. I'm interested in relation to what you said, this would impact on commerce and retail, and I have a background in retail. And I want to paint a scenario, not as graphic as the Chairs, or hopefully not as controversial, but that scenario is that I have a small newsagent shop next door to a school, 300 to 400 kids at the school. One person works in the shop, and currently I have a sign in the window saying limited numbers of school children allowed at one time. How is that legislation, if it was brought through here, going to impact on a person like that?
Well,
because those small businesses are dotted throughout every town in this province and around every school.
Well, I think Robin probably is well placed to answer. Each of us could give you the answer, but rather than us, who may have a vested interest, maybe I'll allow Robin to field that one.
Should I say also that, I mean, in a sense, you bring a realism to this debate by this particular example. I'm going to counter it before I answer it by saying I bring a realism to this because I also sit as a judge. I'm a recorder and I deal with criminal cases, and I know about the situation where, for instance, post offices are attacked in situations where they're remote and they're not adequately protected. So the issue that you're actually addressing is not because you hate school children or dislike it. Of course it isn't. You want their custom. That's what you want. The problem that your employee running that shop has is security. That is the problem. You're concerned that you've got too many people to watch in order to make sure that the security is working within that shop. Your situation is not unique. There are many small stores with single employees who are running them. Now, what you're really saying here, it seems to me, is this, is that you cannot have disorder within your shop, and you cannot have too many people in your shop at one time. Your aim is security. The measure is to achieve that security within the shop. You've taken a shortcut with your notice. I would say, under this law, that the notice by itself would cease to be lawful. Your aim of security remains entirely lawful. You have to have a proportionate means of achieving that. Now, it might be to say, and we see this quite commonly, certainly on my side of the water in GB, not more than 5 people in the shop.
Absolutely.
You see that. And you might say, and I've seen this, for instance, with petrol stations where there's a limited number of cars on the forecourt. I've seen rules of that kind, for instance, and where there's been a danger that the people will drive off the forecourt or anything of that kind. So your aim of security is entirely legitimate. Your assumption that school children are more difficult to deal with than adults isn't necessarily right. You could have 6 perfectly decent A-level students, and you won't let the 6th one in on your rule. And that's the problem with it. So it's the shortcut that's been taken to a destination which is lawful, security. You just have to change the rule and say not too many people in at once. That's how it would be dealt with.
So it's people rather than young people.
It
So
is.
you could have 20 teachers come out of the school at the one time. Do you say to them, sorry, you can't come in?
I think that makes the point. I mean, if one tests this another way, it's a stag do in the pub next door, and they've all had too much to drink. You don't want 6 of them in the store any more than you want 6 very rowdy, hyper, on a windy day, school children. What it is, it's about security, and the rule has to be appropriate to say how many can you supervise.
And in an ideal, sorry if I can go back to you, in an ideal world, what you say is correct, but that's not the reality. The person operating this small CTN is there 18 hours a day, 1 staff member, no profit margins, but there's half an hour in that day when the schools are out. And that's the time that we will have big numbers.
Well, I don't have, let me be perfectly clear. I have no objection to a rule that says not more than 4 people in the store.
Or 6 or whatever. Yeah.
Or 6 people, or whatever it is. There's nothing wrong with numbers, but to assume definitively that those numbers only apply to school children doesn't work.
This legislation that come through will very directly impact on people like I have just discussed.
Absolutely will. I don't disagree with that.
Well, Stephen, may I say something else? I mean, in our day-to-day work, we would get people, members of the travelling community, coming in and saying they've been badly served in shops on the stereotype that all travellers are going to cause problems. Now, you may have had travellers who have caused problems, but that in and of itself isn't sufficient for you to say no travellers. Okay. And that was a hard one for people in some areas. And we're simply saying, no, if you have a problem with dealing with mass because you've only got one, you wouldn't say only boys because, or only girls because maybe you've had more a problem with boys. This is actually about saying we can only handle 6 or 8 people. That would be, in my view, a perfectly legitimate sign to have, whether CCTV or not, and therefore you're not discriminating on the grounds of race or in anything else. And people then are adults, so well,
yeah, can I ask you a second question? And that is, Michael, you talked about, and you've talked several times about the 3 countries that have adopted the legislation.
Yeah.
Is there not one other country in the EEC of the 27 countries that have?
Belgium's the only one I'm aware of.
Well, Belgium is the most advanced,
as a relatively new,
Sure.
devolved government here, is it right that this is a priority for us ahead of the rest of the United Kingdom and ahead of the Republic of Ireland and every other country in the EEC?
Well, let me just, I'll say something very briefly on that. I think what I said is, we've argued sometimes,
Patricia, maybe you don't like my question. I can see the facial expressions you're making, maybe, but I have a right here to ask a question.
And I'm not saying that you don't have a right.
Let me just
I can see your facial expressions.
Sure. We have 3 things very briefly. 1, we've never been afraid to be the first. Now, you mightn't like Section 75, some people, but we ploughed the way. Fair employment, equal opportunities, we ploughed the way. Our plates, we ploughed the way on it. Seat belts, we ploughed the way. I was in another life and insurance industry. We have said if we believe something, we do it. We have a commitment to children and young people. It is core to both to Buck and to what you and the Assembly have agreed. To not have under 18s would actually fly in the face of that. And the third thing is, the reason it didn't happen in Britain is their demography is also different and they didn't have the serious engagement. Robin can fill you in the detail of this. They have an older and increasingly aging population. We have an increasingly younger population. So my argument is, why not?
Okay, thank you.
And can I just come in on the back of that? What I meant was that simply because the rest of Europe hasn't done it doesn't mean to say that we shouldn't do it. And this legislation is before this House at this time, and that's why we're here to give this presentation to you. We're not saying, well, we're not going to bother because it's not in the rest of Europe. So.
But the legislation isn't before this House at this time.
But I mean, it's in discussion with this.
Progress was before this House.
It's in the programme for government. It was the government that put it into the programme for government.
Well, could we suggest, if the legislation were drafted and it went out to Northern Ireland PLC for consultation, what risk is there if it goes out to say, what would you feel if we introduced this and it went to a free vote in the Assembly? I'm not sure what there is to fear for asking that, because the Stratagem survey of politicians actually said 70% plus say we would like this. And our experience, anecdotally and otherwise, is that people are up for this.
Well, with the mention of the stratagem survey, we pass, I think, appropriately to the Deputy Chair, Chris Little.
Oh, thank you, Chair.
I know you're going to mention it. I just know you are.
I'm not. I'm going to mention an Assembly vote, which is possibly even more.
But your eyebrows went up at the mention of Unionist and Nationalist only.
Oh, yes, sorry. I felt left out as an other in this Assembly. Yeah, so thanks, Chair. No, what I was going to reference was the fact that in March 11, 2013, the Assembly voted in favour of the age discrimination legislation extending to all people of all ages, and indeed an amendment to exclude under 18 was rejected by the Assembly as well. So there is a point of reference there. My party, Alliance Party, supports the extension of the legislation to people of all ages, and indeed was positive to welcome the Don't Exclude Us campaign to the Assembly today. You asked the question, what I think we do. There are obviously concerns though, and people have every right, Chairman of this committee has every right to ask questions in relation to those concerns in order to try and progress us towards delivery. You mentioned what more can be done, and I think communications sound like they may well be important. Those briefings, the extremely detailed work that you've done, it may be worthwhile distilling those into 1 page, 2 page, that people can bust those myths with even greater ease than has been attempted so far. And indeed, I'd be interested to hear what engagement you've had directly with OFMdFM, because using the Assembly motion as a point of reference, it would appear that the DUP in particular have particular difficulties with the legislation extending to all ages. I would support, as you've said, this move into consultation to allow people to express detailed response if that's support, if that's concerns, and allow us to have slightly more substance in terms of where we go from here. But I certainly support, as my party does, the extension of the legislation, and I'm keen to progress it forward like yourselves. Thanks, Chair.
Can I just say on a partly response, we did offer the Robins offices to special advisors, to parties, party briefings and so on. We also offered, actually at a meeting with the juniors, half a dozen months ago maybe, 4 months ago perhaps, that we would actually be willing, staff would be willing to give briefings to the parties. I mean, we have actually genuinely offered now, timing and everything else, we understand that. But the idea of digesting this, there was a short digest of this made, I think, as well, which is in your packs.
Okay.
But if you're saying, Chris, that maybe is still too detailed, there's not a problem. But Robin has a very strong offer where he says there is a workable solution to this for the concerns that people have. For every one of the concerns, we believe there's a solution. Maybe it's that engagement.
I think so, Chair. I found it very helpful in response to Mr. Moutry's question, a completely legitimate concern in relation to security of shopkeepers, and a helpful response that says on grounds of objective justification you may well be able to limit the number of people, not the number of school children, and I think that makes total sense and is a helpful response to a legitimate concern. Maybe we need to get into that sort of detail and tackle specific legitimate concerns, specifically.
And I think that's why we're here today. We understand that there are legitimate concerns by a number of people, and what we're trying to do is help a way through that, and to maybe explain where we're coming from and give some help and support in order for them to be able to understand it better. That's all we're trying to do.
Chair, just one last comment. It is clear, as you outlined perfectly, however, that timescales have slipped dramatically, and I think perhaps the committee could seek further brief or correspondence with the department as well in that regard. Thanks, Chair.
Okay. Megan Fair.
Thanks for your presentation, and apologies for missing the beginning of it, and sorry again if some of this has already been covered, but just by way of comment at the beginning, I do think it's important, and obviously Sinn Féin are supportive of extending this and making it all inclusive, but I do think it's important that we in society recognise children and young people as rights bearers in their own rights from birth, from day one, but at the same time acknowledging and fully respecting parental rights. But in terms of moving this forward, maybe in the spirit of myth busting today, how would a mechanism allowing for ad hoc exceptions be taken forward, and in particular, what would it, again, sorry if this has already been covered, but in terms of financial service providers, what would a practical exemption look like? Or?
There are 2 points in there. Financial services in particular and ad hoc exceptions. Can I pick up, in answering your question, also a point that Mr. Little has made, and actually come back also to Mr. Moutri's point? There are a number of different ways these can be dealt with. You could simply accept the financial services exceptions that currently exist in GB. There is a template there. It's almost completely excluded. Personally, I think that has gone much too far. And I think what happened within Great Britain was that the financial services industry, which is incredibly powerful, got exactly what it wanted. And I would not recommend you doing that, but that is one option that presents. What we certainly recognise is that you would want to be able to allow a financial services industry to assess risk on an age basis, provided it was done objectively. Now, there is European case law, a case called Test Asher, which said that in the field of sex discrimination, objective data that assesses risk on a gender basis is permissible in some circumstances, but it's got to be done absolutely transparently. It's very limited, but there are rules that you could transpose in relation to that. We have not proposed in our opinion that you should exclude financial services assessing risk on an age basis. So I'll say that straight away. Consultation could pull out some of these kinds of problems. The consultation process would bring into this discussion financial services providers. And let's just stop for a moment. People under 18 buy financial services. We know that. They buy insurance from 17 or 16 on mopeds, for instance. They buy financial services in relation to having banking accounts and so on. So you would have to engage with this, but the consultation process would allow some interchange. On the ad hoc basis, it's a very dangerous thing in the field of equality law to think that you can actually see every problem that exists. That's a lesson I've learned over a long career. And so what was being suggested here is that you have some mechanism, if there's a really pressing social need, to allow for legal certainty, to say we must permit an age-based rule in some field that we haven't anticipated in the consultation, to bring that forward, so that OFMdFM, for instance, could have a power within the legislation to make a specific ad hoc exception if there was a pressing social need to do that. That's what's being proposed. That's separate from the consultation. You would expect your consultation process to deal with the problems that confront and to pick them up and see how to deal with them. I want to just add back to my point about codes of practice, because I totally recognise the problem that Mr. Moutray has put forward. I mean, I've got 2 children. They're now in their 20s and their 30s, but I've been through those teenage years and I know the problems. I've said it. I've seen those problems sitting as a judge just as much, and I do recognise them. A proper code of practice would give guidance about the lawful way to address these kinds of problems. There are lawful ways to deal with it. And it would be uniform, and it would essentially make sure that this law is effective because it's predictive. Laws are good if they predict, and you can see reading them, how you have to deal with a problem. And a code of practice would have, I think, to cover exactly that kind of situation. But I don't see that's a problem in terms of addressing it. So I hope I've answered 3 people's sort of questions here and pointing towards taking this into consultation to see what the issues are.
It's just to reiterate the point, it's really important that children and young people in particular have equal access to good facilities and services, and I'm just thinking in terms of mental health services in particular, because we know at present there is a massive underspend and there's no age-appropriate facilities. It's a great point that we're fully supportive of equal access, and appreciate all your support today. And again, like Mr. Little has done, welcome the Don't Exclude Us campaign to the Assembly today.
I think we missed, Megan missed earlier, the fact that we're not saying this is a panacea. And young people should not hear us say, if this comes in, they'll not be on adult mental health wards. This is actually saying a redress will be provided and there will be a legislative framework in which you can proceed. It doesn't preclude government policies and resource allocations and all other things. So lest we be misunderstood, we're not saying all this will change if this legislation comes in. It provides the framework.
That includes for older people as well.
No, absolutely.
It's not just younger people, but older people as well.
Absolutely. Alex Atwood.
Thank you, Chair, and thank you all for your presentations. Clearly, we support the argument and the approach that you're putting forward. Although I have to say that the way things are stacking up, this initiative is going to run into the sand. That we are running out of time in this mandate. We have barely 2 years left. You can see things backing up generally within the Assembly when it comes to law that's meant to go to the floor of the Assembly, including in OFMdFM, and consequently I think we're at a critical point where this does not happen. So your presentation and the attention brought to this place by you and others outside the building today is very important. But besides the fact that there is resistance to a rights-based approach in various ways at various times in this society, is there resistance elsewhere, or if not resistance, some uncertainty elsewhere, such as in the corporate world, to what the consequences of this piece of legislation would mean? You know, is there anybody in the retail sector, for example, who for some reason or other thinks this isn't a good idea, as opposed to what might be the more orthodox uncertainty or reticence about a rights-based approach in this society? And is there any consequences for the age of voting?
Sorry?
Any consequences for the age of voting?
Yeah.
Arising from, because if the previous legislation in 2006, the regulations then, and now we might have law in this regard in relation to goods, facilities and services. It seems to me it's certainly in terms of argument and not in terms of hard law, questions around the voting.
Shall I deal with that? I think the first thing, really, voting is a very simple one. The answer is, as we've made clear in our opinion, it's standard practice in equality law to take existing legislation as is. Voting is existing legislation. So it would have no impact as a matter of law on the age of the franchise, full stop. You make a second point, which is a political point, which is, would it give somebody a leg up to say it should be 16 rather than 18? I have no doubt that there could be a politician who could argue that point, but equally another one would say this isn't a goods, facilities and services, this is a civic right, the franchise, and it should be treated in a quite separate way. It's about maturity and responsibility and so on. So I don't think it's going to change the arguments that we all know about the franchise. You know, you can be sent to war as a soldier before you have the right to vote. You can have sexual relations before you have the right to vote. You can have a parent before you have the right to vote. All those arguments, well rehearsed, they're separate. The retail sector. I know of no, what I would call, fundamental principle-based argument from the retail sector. I've lived through arguments from the retail sector about equality law and have worked with the retail sector myself. I was Special Legal Advisor to the Disability Rights Commission when disability laws were introduced, and I've had to work with the likes of Debenhams and so on about making reasonable adjustments for the provision of access to retail services. It took time. The retail sector sometimes found it difficult to engage with it, and sometimes decided they wanted to be standard bearers in responding to it. I have absolutely no doubt at all that some aspects of the retail sector would see difficulties in this legislation. It would be a very great surprise if they didn't. But there are, I think, some comforting words that we can put in here, which is that we've recognised, for instance, that laws on concessions might be an exception that you'd want to adopt. Very often there are concessions that are related to some sort of age-based rules. And we've talked about this in the opinion. Where you draw the line, what you accept in relation to that would be a matter for debate and consultation. And you would want to engage with the retail sector about marketing that was acceptable and marketing that was not acceptable.
And I think that's no different to, having just received my free bus pass. I know I'm very young. It wouldn't preclude government policy that says there are age-appropriate interventions and policy imperatives. We talked about the glasses earlier on, or eye tests. I think what Robin's saying is you can address these, and this is part of our dialogue, is when issues are raised, there is an answer for them. The problem is, where do you have the space to address those issues and concerns which are really and deeply held?
In the consultation.
In the consultation.
Well, that's one plus this, of course, and which we welcome. This has been brilliant for us, I guess.
Very good.
Well, can I thank you very much, because we certainly note the fact that we've had this sort of tripartite approach with the legal expertise attached, so it is impressive. And I think the message we take away is that we want to go back to the department, because there is a huge slippage in terms of the timelines and the milestones in the programme for government, and as Mr Atwood says, time is nearly out if we're to get it through in this mandate.
Chair, can I just simply echo by simply saying, if there is technical work that needs to be done, and the OFMdFM wants to ask technical questions, I'm very happy to give a response if they get forwarded through the commissions.
And likewise, our offer's still there about briefings to the parties and so on. I just want to thank the young people for being here as well, because this is the point I was making earlier. It's not that we're talking and they're not here. They're here, and I think I've just congratulate them and their very good humour.
Certainly acknowledge those in the public
endeavour.
gallery. A final thought. If anti-age discrimination is passed, do we still need a commission for older people and a commission for younger people?
Yes, because we've got to make sure it's implemented and monitored and evaluated.
What a very good answer. Thank you very much.
Thank you, and all the best.
Thank you very much.
Today. All of you.
Thank you.
Okay, members, it's kind of the second half of the same theme. We continue with the issues with a briefing from the Children's Law Centre. Spot on, 1:45. And we welcome to committee Paddy Kelly, who's Director of the Children's Law Centre, and the Policy Officer, Natalie Wheelahan. And you're both very welcome. Obviously, you've been listening in. Paddy, over to you for opening thoughts.
Can I first of all, thank the committee for the opportunity to give evidence today, I think the committee will actually find that a lot of the evidence we will be given is reflective of the evidence you've already heard from Robin and from the three commissions. We'd also like to welcome the Northern Ireland Executive's commitment in the programme for government to extend age discrimination legislation to the provision of GFS. The Children's Law Centre CLC is a children's rights organisation founded on the principles enshrined in the UNCRC, including that children shall not be discriminated against and shall have equal access to protection. The Children's Law Centre wishes to see age discrimination legislation being introduced in Northern Ireland, which includes children and young people within its scope, so that all children in this jurisdiction are protected from discrimination in accessing GFS. CLC operates a free phone advice line for children and young people and their parents, which deals with over 2,000 issues per year. We have a young people's group, Youth at CLC, who inform our work. One of the issues which young people consistently raise with us is the negative treatment which they receive in society in general, in accessing services, in shops and in the media. Various pieces of research have shown that the tone of the majority of media coverage of children is negative, that the vast majority of children feel they are represented as antisocial in the media, and that this leads to older persons respecting them less. In 2008, following examination of the UK Government's compliance with the UNCRC, the Committee on the Rights of the Child raised concerns about the general climate of intolerance and negative public attitudes towards children, including in the media, and they noted that this may often be the underlying cause of further infringement of their rights. The Committee recommended that the State take urgent measures to address the intolerance and inappropriate characterisation of children within society, including in the media. The proposed introduction of age discrimination GFS legislation has the potential to address the climate of intolerance and negativity that surrounds young people, if children or young people are included in the legislation. The proposed legislation would prohibit age discrimination in the provision of GFS, such as the provision of health and social care, retail services, public transport. And we believe it would send a strong message to all our children and young people that they deserve equal protection from discrimination and are valued by decision makers in society. We believe that the inclusion of under 18s within the scope of age discrimination legislation has the real potential to create a cultural change in the way children are viewed in society, which, from our experience in working with and for children and their parents, is urgently needed. The UNCRC is a set of legally binding minimum standards and obligations in respect of all aspects of children's lives, which the Government has ratified. The UK Government, as a signatory of the UNCRC, and the Northern Ireland Executive, as a devolved administration, is obliged to deliver all the rights contained within the Convention. Legislative and policy development in Northern Ireland should be taken forward in compliance with the UNCRC. One of the 4 overarching principles of the UNCRC affords to all children the right to protection from discrimination. The inclusion of children and young people within the scope of future age discrimination GFS legislation would be in compliance with the Government's obligations under the UNCRC and would be a response to the Committee's recommendations that the Government take urgent action to address negative age discrimination against children, referencing the clear opportunities to mainstream children's right to non-discrimination into anti-discriminatory law. Based on CLC's experience, the exclusion of children from protections of the age discrimination GFS legislation will, we believe, entrench a hierarchy of inequalities, with children and young people at the bottom. Ironically, the introduction of age discrimination legislation which excludes children will in itself discriminate on the basis of age. No other age group has had to justify why they should enjoy protection of what is recognised as a fundamental human right. Protection from discrimination is a fundamental human right. None of the human rights treaties includes a minimum age requirement for protection from discrimination in the exercise of rights. Children and young people in this jurisdiction are already covered with regard to accessing goods, facilities and services, including on the basis of disability, race, sex and sexual orientation. Given children already enjoy this protection on the basis of other grounds, CLC does not believe that there is any evidential or legal justification for the exclusion of under 18s from the scope of age discrimination GFS legislation. Protection against age discrimination already applies in respect of employment. We further note that the inclusion of children under other heads of discrimination has not led to excessive litigation by children. We note Article 14 of the ECHR, as incorporated by the Human Rights Act 98, provides the right to protection from discrimination and enjoyment of all other convention rights. It does not place an age range on protection from discrimination. The Convention rights apply to everyone, and Article 8 covers other status, which includes protection for discrimination on the basis of age. There are a great number of examples of age discrimination being suffered by children and young people, such as children being refused entry to public services, difficulties in using public transport, 16 and 17-year-olds paying adult fares, problems in accessing accommodation, and the use of high-frequency mosquito devices which are used to deter children from areas but are held by all children, including babies. CLC provides a legal representation service for children and young people and their parents and carers, and we have experience of dealing with cases where age discrimination has been suffered by children in accessing goods, facilities and services. We employ a child and adolescent mental health solicitor who, in addition to providing free legal advice and assist to children with mental health needs, represents in 90% of applications to the Mental Health Tribunal involving children. The scale of the needs for CAMHS in this jurisdiction is overwhelming. Over 20% of children suffer significant mental health problems before they reach the age of 18, and this comprises the commonest form of disability in childhood. Statistics relating to the allocation of resources to CAMHS in Northern Ireland do not reflect this need, and we believe this points to age discrimination in resource allocation. In Northern Ireland in 2012-13, only £19 million was allocated to CAMHS, which equates to only 7.9% of the total mental health expenditure for that period. This is despite the fact that children and young people under 18 represent nearly a quarter of the Northern Ireland population. Investment in child and adolescent mental health service is not proportionate to the size of the child population with mental health difficulties or the scale of the need within this population. There is no reasonable justification for this differential in spend. There is currently no forensic inpatient paediatric psychiatric provision in Northern Ireland and only limited inpatient adolescent facilities. Children continue to be able to access age-appropriate services, with a significant number of mentally ill children and young people routinely detained in adult wards, which we believe to be as a result of a limited capacity in the regional children's unit, and this is as a result of age discrimination in resource allocation. CLC employs a barrister to provide free advice and representation at special educational needs tribunals. She has extensive experience of advocating for children and their parents, including children who are being denied access to services in education because of resources being allocated not on the needs of the child but on age criteria, such as occupational therapy not being provided to older children and one-to-one literacy support not being available to children. In some cases, the age of the child has been used to determine the allocation of resources rather than the needs of the child being met. Children who need additional services to access education should have their access to support being determined on the grounds of need. But the reality is that in some cases they cannot access vital services and are being treated less favourably because of their age. Noting it is often parents who approach children for help so that their children can access vital services, it is our experience that parents are supportive of their children having protection from all forms of discrimination, and this would actually be they would be more able to more easily access services if children were covered under GFS age discrimination legislation. We would encourage greater involvement of parents and their advocates in this debate. As the legislation will apply to service providers, there will be no scope for children to litigate against their parents under this legislation. Also, we envisage and support that it will be justifiable under the legislation that parental consent will be required in certain circumstances, as is the case currently. There are various pieces of legislation which vest the right to make decisions about children's lives with their parents. The right to choose which school a child attends is vested in the parent by virtue of the Education Northern Ireland Order 97 under the open enrolment arrangements. CLC would consider that such pieces of legislation will be exceptions under the age discrimination GFS legislation, and the current position will be retained. Further, the draft EU Commission Directive on the Provision of Goods and Services 2008 proposes to ban discrimination on a number of grounds, including age. Discussion and negotiations are ongoing regarding the directive, and there is no agreed date as yet for adoption. However, the draft directive illustrates clearly the intention of the EU Commission with regard to the need for children and young people to be protected in accessing goods, facilities and services. If this directive is adopted, the UK Government and its devolved administration will be required to extend its legal framework to address age discrimination in GFS to children and young people within 2 years of adoption. CLC is anxious to support OFMdFM in respect of any challenges that they may have in taking forward this legislation. To assist, CLC wishes to know the nature of these challenges. To date, we have been unable to ascertain any rational basis for the proposed exclusion of children on the grounds of age from the proposed age discrimination GFS legislation. CLC has been also unable to ascertain, in the event of children being included within the legislation, what the unintended consequences which OFMdFM fear would impact adversely either on their best interest or the parents or carers. Further, CLC has not been informed of the details of assumed legislative and drafting challenges presented by the inclusion of children. CLC will be very supportive of this committee seeking clarification and details from OFM in respect of these assumed challenges. Given the arguments we have made for the inclusion of children and young people within the scope of the age discrimination GFS legislation, we believe there is an imperative in their best interest to include children and young people within the scope of age discrimination GFS legislation. Thank you for allowing us the time to present today.
Thank you. Thank you very much indeed. Could you tell me why you think there's such a long delay in the legislation coming out of OFMdFM?
I think OFMdFM civil servants and the administration will be better positioned to give detail, but we have been following this debate quite closely, obviously, given our concern that children and young people will be included. I think people, some people are concerned in relation to the issues we've highlighted, the challenges legislatively, the unforeseen consequences, and the issue, especially around the issue of undermining parental consent and parental rights. And I think they are genuinely struggling to address those issues and are maybe having difficulty in doing so.
And yet, the previous panel who addressed us seemed to have no difficulty, never mind little difficulty, in addressing those concerns.
And I think the Children's Law Centre would support the information that they gave to the committee. What I'm saying is that I think the concerns are genuine, and I understand the concern there, but I think there are potential resolutions to those concerns. Yep. Both legislatively and in terms of, for example, the issue about parental rights being undermined. If the exceptions, for example, in relation to determining what school a child should go to are retained, which I think it's very clear would be under the proposals.
But if I heard you right, Paddy, you were suggesting that the officials are struggling to address those concerns, whereas the panel didn't have a difficulty. So why should the officials not be able to address those concerns in the way the commissioners and the lawyer did?
I think I would defer to maybe the officials explaining.
Okay. No, you're saying you're following the debate. Are you also pushing the department to get on with it and get to the next vital stage of consulting?
Yes, we've been engaging not just with the commissions here who presented here today, but we've been engaging with OFMdFM and the two parties in OFMdFM. We have a series of correspondence going back to September 2012 with officials in OFMdFM seeking clarification in terms of where the process offering support in relation to the issues we've raised about legislative difficulties, about unforeseen circumstances. We have met with special advisors in relation to OFMdFM. We have most recently met at their request with Sinn Féin in relation to this issue. We've engaged with both the commissions. We've been party to a sectoral grouping that the two commissions have convened to address these issues and try to encourage OFMdFM to move forward. And we're very open to continuing that engagement and giving any support that we actually can. We provided case studies, some of which we've highlighted today, to both OFMdFM and to the commissions to help demonstrate the need for this legislation.
Do you sense any tension between OFM and DFM in terms of extending the discriminatory legislation to younger people?
I think you would need to ask OFMdFM themselves in relation to
I can't ask them if they know whether you've sensed any. I can only ask you if you have sensed any tension.
I mean, our job is to deal in facts and evidence, and I mean, we've presented, we've engaged with them, we've made our case towards them, and I don't think it would be appropriate for me to comment in relation to the workings of OFMdFM.
Okay, members?
Yeah, sure. Yeah, thank you for your presentation. Can I just ask you what your thoughts are around the delay in a European directive coming in this issue?
I wouldn't have, to be honest, Stephen, I wouldn't have the detailed knowledge, but my experience of watching directives come forward, and probably Robin would have been the man best placed to do this, but watching the time frame in terms of European directives coming forward, they do tend to be quite a prolonged process before they're introduced. So beyond that observation and sort of following the debate and discussion around it, I wouldn't have any more insight into what the actual reason.
There was a directive proposal in 2008, but it seems to have stalled, and I was just wondering, did you do anything?
Just the discussions and the negotiations are ongoing, and that this is the intention in terms of the directive, and there hasn't been a date given for any decision, but this I think would be fairly common delay in terms of European directives being taken forward.
Okay. So the executive's not that far behind us.
A marvellous defence. Marvellous.
Thank you.
First, thank you for your evidence, and it corroborates what your colleague said at the earlier evidence session. First of all, has the UN made any comment on the failure to legislate in respect of young people, age discrimination and goods, facilities and services, given the international obligations that London and Belfast have? Have they ever made any comment that there was a matter that needed to get attended to? And then secondly, when you were talking about the nature of the challenges, which you said were genuine, you also said that you had been, I think the language you used, unable to identify any rational basis for concerns. And I think that's right. I think there isn't any rational basis. So why are the concerns genuine?
In terms of the UN Committee's recommendations, the UN Committee in their last examination of the UK Government in 2008, they did make recommendations both around media representation of young people and the need to take legislative reform to address the negative perception of young people in the media, but also recognised the opportunity in terms, based on the UK Government's report to the committee, which stated that they were going to be bringing forward their legislation under the Equality Act, and they recognised that as an opportunity to mainstream children's rights into non-discrimination and anti-discrimination law, and actually urged the UK Government as the signatory to the CRC to do that and to take that forward on behalf of the UK. Now obviously that did happen in GB in relation to the age GFS legislation, and we were very aware and we're very alert to the fact that the UK Government is going to be examined again by the committee in 2016. The date is possibly July. We will be leading for the NGO sector in terms of the NGO report, and this is going to be an issue which we're going to be raising. And we do.
NGOs representing younger people?
Yes, yes.
Across Britain and Northern Ireland? Well,
we're going to be taking forward the Northern Ireland report for the NGOs, but and we're going to be facilitating a group of young people to do their own report to the committee as well. And this is going to be an issue. I mean, it is, as Paddy said in her presentation, one of the big issues that is raised with us is around negative portrayal of young people and how they believe they're viewed. And for us, I think one of the big issues is not to legislate in a way that includes children and young people, sends a really negative message to children and young people about how they're valued in society. And I think that's one of the big concerns here. And so the United Nations are going to be again examining the UK Government in 2016 and looking at the concluding observations which they made in 2008 and 2002, and asking questions about why they haven't been acted upon. And we do have this opportunity now to provide a response which, you know, GB didn't take for one reason or another, but, you know, I think that we absolutely should.
Well, does the UN have any penalty that they can impose beyond expressing concern in the event that in 2016 legislation, certainly in Britain, certainly out of London, won't be in place. It may be in place here, although the odds of that, as I indicated earlier, are lengthening.
Well, there's no penalty as such, other than I suppose to express concern and to make concluding observations and to request that governments take these issues more seriously. But it is interesting that an optional protocol has been taken forward which will allow individual children to take complaints against individual member states. Now, obviously that hasn't been ratified by the UK government as yet, so it's not applicable. Young people here under 18s can't take complaints against a member state for breaches of the CRC, but that is something that is gathering momentum really, and lots of member states are ratifying it, and it is something we would be calling on the UK government as the signatory to ratify. So, I mean, we are moving towards sanctions, possibly not, very heavy sanctions in relation to all of this, but the UK government did sign up to this. They've made a commitment to the CRC, and we want to see that delivered. There is reference to the CRC in our programme for government, and in all of the strategies which impact on children's lives in Northern Ireland. So, this is the opportunity to give effect to that.
And Paddy, the question about no rational basis, but you can understand the concerns in OFMdFM.
Yeah, I think the concerns are genuinely motivated on the basis that most parents are acting in the best interest of their child, and there is a concern that this legislation, maybe without drilling down it may appear to undermine parental rights and may usurp parental decision making. And so I think they're motivated, the concerns are well motivated in that it's protecting children and young people, protecting the role the parents have in terms of nurturing and supporting their children and young people. But they are not rational whenever you look at the evidence and look at the legislative potential in terms of drafting that obviously would have exceptions to protect that decision making for parents going forward, and objective justification when necessary in relation to parental consent. So I think the concerns are genuine and well motivated, but when you actually begin to explore and look at the technicalities around the drafting that Robin has highlighted, then I think those concerns can be assuaged. So I think they both can sit together.
Deputy Chair Chris.
Thank you very much for your presentation. I think there's some really useful key points in this there for us to take away, but I'm picking out that you think that the exclusion of under 18s could be incompatible with Section 75 of the Northern Ireland Act, UNCRC comments of October 2008, and seems to fly in the face of all human rights conventions relating to children and young people, and that all discrimination legislation appears to include some form of exemptions, indeed can include quite a lot. So the conclusion, I suppose, is to get on with this, yeah?
I mean, we would obviously, like our colleagues earlier, like to see this legislation progressing and coming on the statute book within this mandate, provided it covers children and young people without too many exceptions as a generality. And we would welcome a consultation exercise, provided the consultation document is a genuine one which includes children and young people and doesn't on the premise start off by the exclusion of children and young people, because there's no way that the initial consultation document go out there on the premise that you'd be excluding older people. So I think it needs to be an open, genuine consultation, starting on the premises that all ages be covered. It needs to be open for engagement right across the board, from financial sector to older people, to parents, to everybody, and of course it needs to be child friendly as well.
I also think that given the concerns that have been raised around the impact potentially on parental rights in this whole debate, that there is a need to involve parents more in this debate. The organisations that speak on behalf of parents, what are their views, and a consultation is really the only way to start that discussion in a really meaningful way, to see if those concerns actually are the concerns of parents. Certainly the parents that we work for, and obviously the children are our clients, but the majority of times it's parents who are coming to us in order to access services for their children. And we would have absolutely no experience of parents advocating that they would be nervous about their rights being undermined by giving children rights. That has never been our experience, and I would really like to hear more from parents.
Thanks, Chair. Thank you.
Megan Farron.
Thanks, Chair. It's just really a comment. And just picking up on what you said earlier, Paddy, about it's very true that no other age group has to demand or ask for equal rights to all other ages. So it's just an interesting point, and I'm sure in the good work that you're doing with kids and organisations day and daily, you have your own compelling evidence as to where children and young people are discriminated against on the basis of their age, whether it's health or social services or education or whatever it may be. But I just worry that I'm worried that this could be a worrying step backwards in how we view children as rights bearers. Do you have just any comments on that? Or?
Certainly that we would concur totally with that position. I mean, this is a fundamental human right which children should enjoy equally with all other citizens. And I mean, there isn't any justification for excluding children and young people from this. They shouldn't have to argue in the same way as older people shouldn't have to argue for inclusion in age discrimination legislation, the same way women shouldn't have to argue for inclusion in sex discrimination, or should men. It just, I mean, it flies in the face of the very concept of universality of human rights. So yes, I mean, children are rights holders and are entitled to the protection of age discrimination legislation. And I think their inclusion will actually benefit all of us. I mean, it certainly will benefit children and young people, but it will benefit to parents. I mean, I echo what Natalie was saying. The number of children we would have been able to help more easily to approach us to access services for children had age discrimination legislation been on the books. We have to use other legislation that may not be quite as straightforward in terms of advocating for children and young people. But if age discrimination, for example, was there in relation to spend on mental health services, I mean, I think it would begin to address the inequality which is so glaring when you look at the total deficit of spend on CAM services here.
On that point, Paddy, you'll have heard Michael Wardlow making the point that if we go ahead with this, it's not a panacea. And I think one of the examples would have been that while it would not be right or would not be, would be against the legislation to put a young person in an adult ward, it might still happen because of resource issues. So it leads me to the question of how mature do you think the conversation and the debate is amongst young people as to the likely impact and, as it were, the imperfection of this legislation should it go through, that it won't be a panacea?
I mean, if there is a differential in terms of based on age and spend, for example, if that's objectively justified, I mean, then in a sense that will begin to address the issue, but it needs to be objectively justified. I mean, nobody is saying that there is an infinite amount of money, for example, in terms of health services, but there has to be an equality in terms of decision-making as to how that is spent. Currently, we would say there's age discrimination in relation to the spend on mental health services that could not be objectively justified. If the legislation went through, then I think it strengthens the position from which to engage in that discussion and debate about the equality of spend in relation to mental health spend.
But putting it right could take time because it may need the reallocation of resources and the application of those resources over a period of time. You know, if you're talking about building, for example, new wards in hospitals.
That may be the case, but at least you would have a framework in terms of the disability or the age discrimination legislation which to actually engage in that debate. But we have seen and has to be given recognition. You know, it's still a very minimal spend, but we've seen a nearly 300% increase in the spend over a short period of time. So where there is a focus on the issue and a commitment, there can be significant change over a short period of time. And I think age discrimination, GFS legislation would help focus minds and bring about that change more quickly.
But young people understand it is not a sort of click your fingers panacea, everything changes overnight.
I think young people are exceedingly pragmatic and realistic, maybe more so than adults sometimes, in our experience.
I suppose, you know, from the provision of services point of view, you know, just to sort of echo what Robert Allen said, I mean, we would have major concerns about the allocation of resources based on arbitrary age limits being set as opposed to individual need, and that is really, you know, where we're coming from, is that we want to see resources being allocated to meet individual needs, to progress the lives of children and young people and achieve better outcomes. And that's what we hope this will do. It may take time, and it certainly won't be the answer to all of our problems, but it's a step in the right direction.
And the final point was, in your address, Paddy, you said that you felt that the tone of the media towards young people was by and large negative. Did that cover radio, television, local daily papers, local weekly papers?
It would, yeah.
And have you taken any steps to try and address that? And
I mean, the problem is, for example, we would have argued, for example, the BBC should have been designated for the purposes of Section 75, which would have made it more difficult to engage in some of the rhetoric they engage in relation to children and young people. Unfortunately, we've been unsuccessful in relation to that, and we have engaged with the Equality Commission, with the previous Chief Commissioner, in trying to forward that. I mean, we have been raising the age generally. I think it's been widely recognised. I mean, the Youth Justice Review, for example, referenced the demonisation of children and young people. So yes, it's an ongoing piece of work which we have been working both with at body politic with with particular reviews in relation to, and indeed trying to engage with those who may be able to hold the media to account in relation to it. We have engaged sometimes directly with some of your previous media colleagues, regrettably not very successfully, because it's difficult to hold them to account.
Interesting. Interesting. Paddy and Natalie, thank you very much.
Thank you very much.
Members, we are no longer quoted in terms of decision making, so I don't think there is a great deal of point in discussing the forward work programme. So we'll bring a point with regard to the 21st of May meeting forward next week. Is there any other business members wish to raise? If not, we adjourn until Wednesday the 9th, 2 p.m, room 30. Thank you very much.